Greetings. I'm Melissa O'Rourke. I'm an attorney and farm and agribusiness management specialist with Iowa State University Extension and Outreach. I'm here to visit with you today on things that I've seen over the years in terms of farm transition and succession and estate planning mistakes. Over the last 30 years, I've worked with many farm and ranch and other rural and small town families across Iowa, across the upper Midwest, and have had the opportunity to observe what goes well and what mistakes or errors people make. And so I look forward to sharing these 10 particular ideas with all of you and hope you get some good take-home messages. On our first slide, you'll have our contact information for me, and I hope that after watching this presentation, if you have some questions, if you would like to schedule a time to visit with me, that you'll feel free to email me or leave a message, and we'll get in touch and figure out a good time to visit. I want to acknowledge that I'm part of a team here at Iowa State University Extension, a team of farm management specialists. And you see on the map of Iowa photos of my colleagues, and we are all scattered across Iowa. I happen to be housed in northeast Iowa, but like the rest of my colleagues, I do travel around and I meet with Iowans and people outside the state as well. And again, my contact information is there for your convenience. I also hope that you are familiar with Ag Decision Maker. And if you're not, I hope that you take the opportunity to get on the internet and look for ISU Extension's Ag Decision Maker website. If you look at that home page of Ag Decision Maker on the left-hand side, there is a submenu that I've now enlarged. And many of the documents, the ideas, materials that I'll be referencing today are in what's called the Whole Farm section of Ag Decision Maker. If you click on Whole Farm, you get to the page as shown there that says Whole Farm, another submenu on the left-hand side that I'm enlarging. In particular, there is a section called Transition and Estate Planning, and you'll find many materials there. If you click on that, and you would be able to scroll down the page, you'd see many different things that you'd be able to refer to, and that will touch on a number of the subjects that I will be talking about in our session today. Again, another submenu, there is a section called Evaluating Your Estate Plan. In that section, a number of different articles on topics that we will discuss today on trusts or substitute decision maker or property ownership, many different things. In addition, there is a questionnaire called the Estate Planning Questionnaire. You can go and use that, and it will give you a tool to help you get started with your estate planning and transition process. Many people over the years have asked me about how to find an attorney to help with estate planning. And you'll find there's an article on Ag Decision Maker to help you through that process as well. And all of these different articles on Ag Decision Maker are available in what's called a PDF format, and I will make references to these articles and references throughout the program today. So be sure to go look for those when you have a chance, if you haven't already been able to do that. I like to remind everybody in programs like this that nothing is as simple as it used to be. So remember, this is a 60-minute or under program. We can't cover every question, every situation. It's to give you a broad overview, and this is educational information. Although I'm an attorney and farm and agribusiness management specialist for ISU Extension, this is not intended to be legal advice for any individual person. Each individual needs to have their own professionals that they retain for their legal advice, transition, tax, estate planning purposes. The first mistake that I've seen so many times over my years, decades in working with farm and ranch and rural families is procrastination. We're going to get to it someday. That's something that we really need to do, but we just haven't done it yet. So I tell people, stop the procrastination. Take a look at the picture of the farm there. You don't let your farm look like that. You keep your farm updated. You don't let things get run down and beyond repair. Hopefully, all of your fencing doesn't look like this. We all have some repairs and updates that we need to do now and then. We sometimes do have to do things on the fly, cobble things together with the zip ties and the baling wire and the duct tape. But we try to get projects done and try to keep things done the right way. So I say to everybody, get up, get going, stop putting it off, and start doing the tasks that you need to be doing to make sure that your farm has a good future and that you have a plan in place. I'll ask you to think right now, when was the last time that you updated your plans for your family and the future of your farm? Our research shows that 89% of all farmers do not have any kind of a farm transfer plan. 60% of farmers don't have any kind of an updated estate plan. Many people that I talk to say, well, I want to go to another program or read a little bit more or talk to somebody else, and they're waiting for that perfect plan. And I say to people, there is no perfect plan, but some plan is better than nothing. If you die with no plan, there is a plan out there, and it's the state's plan. When you die with no will in place, that is called dying intestate. And so then what we call the laws of intestate succession come in. And so then you get the plan that the state has put together. And that may very well be not the best plan for you and your family and your farm or other business. So that's not what you want to have happen. So get going. It really does lead us into the number 2 top mistake that I see, and that is the folks who make no plans for substitute decision-making, healthcare directives during their lifetime. I call this having a plan in place for before you're dead, okay? Because there are times in your lifetime that you may be unable to speak for yourself or make your own decisions, and you need to have a plan in place for yourself, your loved ones, when that happens. And so we're talking about things like powers of attorney and healthcare planning and directives. Now, when I use the term incapacity, we're talking about that lack of physical or mental abilities that result in your inability to manage your personal care, your property, or your finances. And when incapacity takes place, somebody needs to be able to step into your shoes and have the authority to act for you. And don't just assume, if you happen to be married, that that is going to be the job of your spouse, because your spouse may or may not be able or willing, or they may have predeceased you. They might not be available to act on your behalf. So you have to have some plans in place for what do we do when we need help. Let me just talk for a couple of minutes about different kinds of powers of attorney and directives. The most common kind of a power of attorney is the one that we have in place for your business or financial affairs. It allows a person that you appoint, who we call your agent, to act in your place if you're unable to handle your own business or financial matters. Now, that document, it needs to be a properly written and signed and witnessed document. It spells out the powers of that agent. Things like, do they have the authority to pay your bills, file income taxes, sell property or lease assets? That could be farmland or other farm assets. How about collecting money that may be due to you? You would want the agent to have those powers, and they can be much more detailed than that. But those things need to be spelled out in that business power of attorney document. And then there's a power of attorney document for your medical or health care purposes. That is the person that you want to have step into your shoes to make medical or health care decisions for you when you can't make those decisions yourself. Now, it's possible that that person you appoint could be the same agent that you appoint to handle business matters for you. But it might be somebody different, and that could be for a variety of reasons. You might choose one person who's really good at handling business and financial matters. But when it comes to making healthcare decisions, some of those that might be very emotional, you might choose a different person. So think about that. It could be the same person or it could be different people. Right? So you want to have that agent appointed for you if you can't express those decisions for your medical or healthcare purposes yourself. So again, the document will spell out those powers of that agent. Would that person consent or reject hospitalization for you or other kinds of treatment? What about organ donation? And again, make decisions about how much health care and how much treatment you want at various points in your life or depending on your condition. I'm going to give you a few guidelines that go along with these power of attorney documents. Number one, name at least one alternate. For those of you watching this who happen to be married, very often if your spouse is of good health and so on and is surviving you at that point, that's your first choice very often. Might not always be, but generally is. But again, it's just not common that maybe we haven't updated these documents and perhaps your spouse has become ill or incapacitated or has predeceased you. So you want to have at least one alternate and oftentimes a second alternate. So think of it this way. I appoint A as my agent, and if A is not available, then I appoint B. And if B is not available, then I appoint person C. So it's good to think that through and name those people. Avoid co-powers of attorney, co-POAs. Where I see that happen is sometimes where people have, 2 or 3 or more adult children, and they think, well, I'll appoint them all to act together as a committee. That oftentimes makes for difficult decision-making. I'm going to talk more later about communication, but I urge people in powers of attorney to select the one person who is going to be most accessible, sometimes most geographically accessible, who you feel is going to be most able, and then again, choose person B and person C, and then communicate this. Give copies of this to everybody who needs to know. And so don't worry about making somebody feel bad that you didn't appoint them. You just say, this is what I have decided, and I want everybody to be informed. Think about people who are younger than you. The reason I mention this is oftentimes a mistake that I have seen is people appoint their spouse, and then if their spouse is not available as person A, they appoint perhaps a sibling, a brother or sister. Well, think about that. If you're getting older, and maybe you're in your 70s or 80s or whatever age you might get to be where this could be needed, your brother or sister might be the same age and not really available. So think about children, grandchildren, nieces, nephews, and remember, this does not need to be a person you're related to. It could be somebody else, a family friend. It could be another professional person. So you have a lot of choices there. I already mentioned that your healthcare or medical agent and your business financial aid agent, these could be different people. You need to be competent when you sign the power of attorney. So that's why you don't want to procrastinate. Remember, mistake number 1? You don't want to wait until somebody is suffering from possible dementia, Alzheimer's, or other medical situation where they are not competent, where they lack that legal capacity. Do it now. Don't put it off. because you need to be competent when you sign these documents. And remember that the power of attorney is only good during your lifetime. I often get asked the question, my mother just died and I'm her power of attorney. Don't I get to keep paying bills for her, or things like that? And the answer is no. Once that person, what we call the principal, dies, the agent's power dies with that other person. Another tool that has to do with substitute decision making is called the living will, and it's often also called the declaration relating to the use of life-sustaining procedures. This is you expressing your desire of what kinds of life-sustaining procedures do you want used depending on your medical condition. And so the idea is, how much do you want done for you? Do you want to be tube fed? Do you want other kinds of heroic, perhaps, life-sustaining procedures to be continued for a long period of time? Or are you choosing to simply have maybe hydration, pain medication, and let things take their natural course? The person who would be making those decisions, oftentimes that person you've appointed as your healthcare power of attorney, they are going to consult with medical professionals and look at what you say your wishes are. This document guides the healthcare power of attorney. And so remember, please consult with your own legal attorney for writing out and expressing these things in the language that will be appropriate, that will express your desires of what you want done. And then again, give a copy of this to everybody who could need it, because copies, signed copies, have the same force as the original. Another piece of substitute decision-making tool or directive is called the Do Not Resuscitate, or DNR order. There are two different kinds. The first one, called a physician-issued DNR, that's used often when somebody is in hospice, they're in a terminal condition, and it allows emergency care providers and other people outside of a hospital to rely upon that and not attempt resuscitation. If the person has said, no, if my heart stops, I do not want to be resuscitated. And the other is a patient-issued do not resuscitate order. And this could be, depending on your health, your age, and so on. There are people that say, if I'm going in for hip surgery or knee surgery and my heart stops, I don't want to be resuscitated. And that is a choice that the patient has a right to make. Again, discuss these things with your family, with your medical providers, and work with your attorney to make sure the document expresses what you want. And keep all of these documents together. You can have the living will and the power of attorney for healthcare decisions as a combined document. If that is desired, you would want to talk to your attorney about that. I also want to mention that there are some agencies out there, government agencies, even banks, other investment organizations that you might work with that have their own power of attorney forms, and it can be helpful if you've filled these out ahead of time. The IRS has a power of attorney form, so if it could happen that you need somebody else to deal with the IRS on your behalf, file taxes for you, filling out that IRS power of attorney could be a helpful thing. The Social Security Administration has a form for appointing a representative, so somebody else can communicate with the Social Security Administration. The Iowa Department of Revenue, if you're dealing with various kinds of Iowa taxes, they have a power of attorney form, so someone else could deal with Iowa Department of Revenue. We have a sample of an Iowa out-of-hospital do not resuscitate order. So you can find forms, but again, I encourage you to work with your attorney in getting all of these forms done so that you have a package done where all these things are done right and they're done correctly with the correct language. I mentioned Ag Decision Maker. You will find on Ag Decision Maker a resource, one of those PDF documents on powers of attorney and substitute decision making. You read through that, it will review all of the things that I just talked about, and it'll help you when you go in to talk to your attorney about what your wishes are and how you want things worded. Mistake number 3, I mentioned this already, communication failures. So are you putting together those communication pieces? Let's talk about this a little bit. As I mentioned earlier, there should be no family secrets in estate or transition planning. Everybody should know what's going on. Think about this really. You shouldn't have anything to hide. And when people in your family, be it with what is in your will, what is in your trust, or those powers of attorney and healthcare directives, why not give copies of those to everybody? Be open, be clear, tell everybody in the family about the decisions that you have made so that nobody's questioning or having bad feelings later. Discuss these things early and often. Figure out what works for all. You don't want to be the person who is waiting till they're older and your children are older and you even have adult grandchildren. Again, it's never too late, but everybody should be talking about these things throughout their lifetime about what's going to work best for everybody. Have family meetings. Set regular times for those farm and family meetings, be it once a year, twice a year, every month. It depends on what you need. But have those things on the calendar, have them held at regular times, have an agenda, keep minutes, share information. And if your family, and trust me, most families out there have maybe some issues, some unresolved, perhaps hard feelings. That could be your family. Don't feel like you're the Lone Ranger, but think about then getting some kind of an outside person. And that could be an extension person. It could be a local attorney or a other kind of professional, a mediation professional who could help to facilitate those meetings and get the conversations going. You need to start somewhere. And again, as it shows on the slide there, remote meetings are just great. And I think many of us have learned in these last months how to use remote meetings. And especially when we have family members who are in different places in the country or around the world, you don't have to put off having a family meeting because everybody isn't right there. Use those tools and meet and have conversations and share information on a regular basis. So many benefits. You're creating that trusting atmosphere. You're setting goals for the family farm. What are your dreams? What are some possible strategies? Making decisions about, are we going to expand an operation, cut back? Are we going to delegate responsibilities for certain things? Solve problems, solve differences, misunderstandings as they arise so that they don't fester for some long time after that. Share that financial information and other decisions. Record your agreements. As I said, take minutes. I have a family who's been doing family meetings on the farm for many years, and they have a stack of just spiral school notebooks, and each time they have a meeting, they take good notes and write it down, and really they have a family history there. So start yours now. That'll be wonderful. You're building family unity by doing that kind of thing. And I often get this question of who all should be involved. So the illustration is this, that I know families that generation one might be somebody in their 90s. And the next generation, and those people, they still own farm assets and things are residing with them. The next generation then is their children, the people in their 70s. You want to involve them. Well, we keep going. You see where this is headed. Their next generation is people perhaps, in their 50s. It's hard to say. Next generation, people in their 30s. And in reality, there might be some children. Well, it doesn't hurt if you're having a family meeting to bring in, depending on their age, and they could be children, teenagers, let them do a show and tell about a 4-H project. Let them listen for a while, and then they might be excused till later. But it gives everybody an opportunity to see that what we're doing here as a family is we're having conversations. We are talking about things. We're having civil conversations, and if we have a difference, we learn how to deal with our differences and air those differences and move forward. So involve as many people as you can, and I also say if there are in-laws, spouses, include them if at all possible, because they are part of the family. If you want them to feel excluded, then exclude them. But you're generally going to be better off including everybody that you can in these conversations. You're building and fostering that family unity. I said earlier, give people a copy of your will or your trust document. This is an outdated concept that you see on the slide there. People used to say, oh, after somebody dies, then this day comes that we'll go to a lawyer's office and there will be the reading of the will, and now we'll learn what grandma or grandpa or mom or dad said in their will. That should not be part of your plan. Everybody should already know what's in it. Give them a copy of it. If you've made decisions about treating different people differently, it's so much better to have that out in the open, explain what you're doing, and not have children or siblings having hard feelings later after somebody is dead. You don't want that to be your legacy. Mistake number 4. I've kind of just touched on that. It's a mistake to try to say in all situations that we're going to treat everybody equally who might be an heir during lifetime or beyond, while failing to consider what might really be fair, especially in that family farm, family business situations. When we make those decisions about what might be fair or equitable, we need to think about that and say, we don't have to do everything equally, because treating everyone equally, depending on who they are and where they are in life, it might be the most unfair thing that you could do. Think about this, and a lot of farm families don't realize this, but in America, 80% of Americans receive no inheritance at all. So drive or walk up and down the streets of your town, your community, look around and understand that most people in America receive no inheritance. And then there's that other 20%. So think of the room of 100 people. There are only 20 of them that are going to get any inheritance. And of those that do, the median amount, meaning if we line it all up and pick the amount in the middle, is about $49,000. So if we have a farm ranch situation or the business situation where there's more involved in that, yes, it can make room for some hard feelings and how are we going to divide things up. But think about how fortunate that family is compared to most families in the United States where there is no inheritance. People are just kind of trying to live and finance their lives through their lifetime, and then they move on. I've already mentioned and will continue to mention some documents on our own ISU Ag Decision Maker, but I like to mention our friends at the University of Minnesota Extension. They have a very nice series of articles that they call the Transferring the Farm series. You can just Google it and you will find it. It's a 30-some page document with a series of articles in it. And these things that I've just been talking about, fair versus equal, this is what is discussed in this series of articles. It's a discussion of lifetime gifting, how do we treat heirs, how do we value what's called sweat equity that people have put into the farm over the years. These articles talk about how do we protect on-farm heirs and off-farm heirs. And this particular article is called Treatment of the Heirs in the Transfer Process. Very good article, has some nice illustrations in it. Another article called Putting a Value on Sweat Equity outlines some different methods that you can think about. We say, well, if somebody has contributed a lot to the farm operation over the years, it might be decades, how do we evaluate and place a value on those contributions and perhaps reflect that in our farm transfer plan? So again, good illustrations and ideas, and it's not a one-size-fits-all. Every family is different, but it gives you things to think about, and these are things that you can talk about in your family conversations and meetings. So keep these things in mind. Mistake number 6 is the failure to take inventory. Inventory of what property you own and how do you own it. And then go on and say, is what I own and how I own it, is it coordinated with the farm transfer plans for lifetime or at death, the estate plan? So let me talk just a moment about real property, real estate. And you see on that slide there just a little small image. It's an article on Ag Decision Maker about property ownership. When we talk about real property, we define that as land and anything that's attached to it. So that includes buildings, fencing, subsurface tiling. All of that is part of real property or real estate. And then there is personal property, and there are 2 kinds of personal property, tangible and intangible. Tangible is anything that you can touch. So you see some jewelry, farm implements, cattle, toys like boats and RVs and things like that. And then the intangible personal property is things that have value that you can't touch. Bank accounts, CDs, stocks, bonds, investment accounts. You can't touch them, but they do have value that you can use. So we divide those 2 different kinds of property. Talking a little more then about the real property, real estate, and the intangible personal property, much of those kinds of property can be owned individually, just by one person, or jointly with 2 or more people. It's very common in real estate to have fee simple ownership, which is an unconditional power to use or transfer the property. And that term, fee simple, comes from the old medieval term that you might have heard, a fiefdom. That's fee simple, a very strong ownership power. But in America, much of our real estate is co-owned. And in Iowa in particular, there are 2 main kinds of property co-ownership. And we see this in other states as well. One kind is called joint tenants with right of survivorship, sometimes abbreviated JT or JTWROS. And the other kind of property co-ownership is called tenancy in common, and sometimes you would see that abbreviated as TIC. And I will give a little more explanation of each of those. Joint tenancy with right of survivorship always involves then 2 or more people. We most commonly see it where 2 spouses own things as joint tenants, but it can be more than 2 spouses, and they don't have to be married at all. But they always have equal shares. So if it's 2 people, they each own an equal share of 50% each. If it's 3 people, it could be 3 siblings owning it together as joint tenants. They would each own 1/3 each. Now, nobody in that group of owners, be it 2 or however many more, they cannot sell or transfer or mortgage the property, their share of the ownership, without the consent of all the other joint tenants, whoever they are. And the right of survivorship is like a built-in will. So if a pair of spouses owns a piece of real estate as joint tenants, when one of the spouses dies, there is an automatic transfer to the survivor spouse. When the owner dies, that ownership interest ceases. So in that picture that you see there, let's assume that's a husband and wife. If the wife dies, Her ownership interest dies with her, and her husband becomes the sole owner. So that's built in to the ownership strategy. If she had put together a will that said, and when I die, I want my share of ownership to go to my nephew, it wouldn't work. She didn't coordinate her property ownership strategy with what her estate plan was. So that takes us to the other kind of joint ownership, which is called tenancy in common. Right? Tenancy in common, again, sometimes abbreviated TIC. So again, you have two or more owners. They have separate but undivided interests, and the shares might be equal or they can be unequal. And I will give you an illustration of how that happens. There is no right of survivorship. The shares pass to the heirs. So in the illustration that I just gave you, if there was a husband and wife, and they were owning property together, but the wife said, if I die, I would like my ownership to go to my nephew, not to you, my husband. That could be done, but they would need to own that property as tenants in common. Then, when she died, it could go, her husband would continue to own his 50%, but the wife's share could go to that nephew. So that would be coordinating the property ownership strategy with the estate plan. So let's go on with that. I'll give you a little more of an illustration. This is an illustration of how what we see very often in Iowa and throughout farm country is the idea that we want to keep the farm in the family, we want to keep that land in the family, and that the way we're going to do it is just keep dividing it up among our children, and oftentimes we see that done as tenants in common. So we'll take an example, and this will only go 2 generations. So let's say we have, they were mom and dad, now they're grandma and grandpa, and they own a section of ground, 640 acres, and maybe during their lifetime, they own it as joint tenants. And grandma dies, and now grandpa becomes the sole owner, and grandpa always said, I'm going to farm until I die, and so now he owns that whole 640 acres. But during their lifetime, they had 4 children, and I'm just calling them A, B, C, D, Alan, Bill, Kathy, and Donna. And so when grandpa dies, they had always said to the kids, we're going to keep the farm in the family. And so mom died, then grandpa died, and so at his death, the will says, to my 4 children in equal shares as tenants in common. So now Alan, Bill, Kathy, and Donna own that 640 acres as tenants in common, and they each own 25%. Remember, they don't each own 160 acres. They each own 25% of that whole 640 acres. And it was drilled into them throughout their life that we keep the farm in the family. And so they start to continue that pattern. And sometimes it works very well, and sometimes it doesn't. The fact of the matter is, since Grandpa had said, I'm going to farm until I die, that Alan, Bill, Kathy, and Donna, none of them went into farming. And so each of them maybe had some children. They'll have some heirs. So what happens as they start dying? So we're just going to that next generation. When Alan dies, he had 4 kids. He says, to my 4 children in equal shares, we're keeping the farm in the family. They'll own it as tenants in common. So now Alan's 4 children each get 1/4 of his 25%. So they each own 6.25% of the 640 acres. And Bill, Kathy, and Donna, who are still alive, all own their 25%. So we now have unequal shares as tenants in common. Now Bill dies. He had 5 kids. His will says the same thing. To my 5 children in equal shares as tenants in common. Now they each own 5% of 640 acres. So at this point, we have 9 cousins, Alan's kids and Bill's kids, who each own various percentages of the 640 acres. Kathy and Donna are still alive, owning their 25%. Kathy dies. She had 3 kids. to my 3 children in equal shares as tenants in common. So now they each own 8.333% of 640 acres. So now we're up to 12 cousins. And then Donna, Aunt Donna, she still owns her 25%. And Aunt Donna, when she dies, she had no children, and she decides to leave it to the church. So the church gets all of her 25%, and the church really wants to sell it. They don't want to be farmland owners, so they can sell. And then maybe some of those other cousins, none of whom live in Iowa, say, we would rather have the money. And so do we really even have a farm family? So this is the kind of thing that often happens in one generation, especially if you have not had conversations and you haven't had a farm transition plan. So that isn't what most people want to see. And, if the land is being rented, you have a farm manager taking fees, rent checks are going to grandchildren outside of the state. You don't really have a family farm, you have a family landholding group, and then we bring in the church and it all gets very complicated. These are the kinds of things when there's not really a farm transition plan, there isn't conversation about a family plan for that farm in the future. So we can all do better than this, but it does take communication and understanding property ownership strategies. So try to do better. This is something that I saw happen once. Fred and Wilma, they were a farming couple. They had 3 sons. They owned quite a lot of land. As part of their estate plan, they went to their lawyer and they said, well, we have these 3 80-acre parcels that are similar. And when Fred dies, he's the sole owner, and we want each of the 3 boys, Alan, Bill, and Charlie, to get one of those 80-acre parcels. Fred died, and then they found out that Fred didn't really own those parcels. They had been transferred to Wilma in some prior financial planning, so Wilma still owns them. So knowing what you own and how you own it and taking inventory is very, very important. So know what you own and know how you own it. Again, on Ag Decision Maker, you can read more about this, understand about property ownership, and have those conversations, take those inventories, and you can do better. I'll mention very quickly bank accounts, other intangible assets, investments, they can be jointly owned. Sometimes people put CDs or bank accounts into joint ownership with a child or another caregiver. Just think about those things. Think about what your goals are. Have conversations. Talk to your tax and your legal advisors and make sure it's doing what you want it to do. If you're going to have an adult child or a caregiver, be a joint owner, think about other considerations having to do with creditors, people that person might owe money to. What happens in the case of a divorce? I've seen it happen too many times where a joint owner starts borrowing from a parent's account, and that maybe is not what is intended. What about if the parent dies and one of the children is a joint owner with the parent? They now become the sole owner of a bank account. Was it intended that it all go to that child or not, or should there be sharing with the other children? Think about what the goals are and what the estate plan is and communicate about those things so that you don't have family fights in the future. So, very basically, I'll just tell you to ask yourself some questions. Do you know how is all your real estate owned? Again, remember Fred and Wilma. They thought Fred owned those 380 acres. He didn't own it. They weren't sure about the ownership. So oftentimes what you think you remember isn't accurate. So go back and do a good inventory. How about the bank accounts? Sometimes we find out after death that a bank account is jointly owned or solely owned. Take inventory of how all those things were owned. Life insurance policies, how are they owned? Who are the named beneficiaries? How about pensions? Have elections been made? Are there beneficiaries? Some of those kinds of accounts have beneficiaries on them. And then, please, think about personal property. I'll just say very briefly here that oftentimes at the time of death, some of the fights that I've seen over the years have been over personal property, items that perhaps are not worth a great deal of money, but they have a lot of sentimental value, and I urge people to make plans for those personal property items, give them away during your lifetime, or have a very clear plan about what should happen to personal property at the time of death. Number 6 mistake, don't make decisions about your plans based on incorrect or inaccurate information regarding taxes, and that particularly includes the federal estate tax or Iowa inheritance tax issues. So I'm now going to give you a very brief overview and show you some references so that you have a good understanding, just to get you started, of some tax issues: Iowa inheritance tax, federal gift tax, and federal estate tax. So, Iowa inheritance tax. Sometimes we hear people talk about death taxes, and they think that at the time of death, there's going to be a great deal of death taxes if they leave some land or assets to children or grandchildren. I want you to understand that in the state of Iowa, the law is this, that if any items are left, first of all, to a surviving spouse, there is no tax in the state of Iowa. Okay? There is no Iowa inheritance tax. If you leave land or other assets to lineal descendants, which includes children, stepchildren, grandchildren, great-grandchildren, again, talk to your legal advisor, but when we think about that family tree going straight down the line, there is no tax on that. If you leave things to a charity, a 501c3, a religious institution, a church, educational institutions, there is no tax on that. Okay. You can find more information on Ag Decision Maker about inheritance tax, and you can find more information at the State of Iowa Department of Revenue site. Again, if you're going outside of those lineal descendants and leaving it to friends or nieces or nephews or cousins or siblings, then there is tax. It isn't really that much, but you'd want to be aware of it. But you definitely can do that. But if you're going with lineal descendants or a surviving spouse or charities, there is no tax. So don't make decisions based on a mistaken belief that there is a state inheritance tax when you're leaving things to children or grandchildren. Very quickly, federal gift tax. There is a nice piece of information on Ag Decision Maker that describes some of the details about federal gift taxes. But people oftentimes have this mistaken impression about gifts and the consequences. So very briefly, what is a gift? A gift is when one person voluntarily transfers property, which can include money, from a living person to another living person, and it's completely free of any payment or strings attached. It's a true gift. We're giving a gift. It can only happen during lifetime between living people. Because remember that lifetime gifts, those are true gifts. Those are different from when somebody leaves what sometimes people call a gift in a will, and that is more properly known as a bequest. It's not truly what we call a gift. Gifts, remember, are not income to the person receiving them. So if during your lifetime you give a gift to somebody, as we described, one living person to another living person, and if it's a gift with no strings attached, they didn't earn it, then that is not income. There is not tax due on that. And people say, but what about gift taxes? So I'm going to give you a brief explanation of gift taxes as well. Why do people give gifts? Well, people give gifts because they want to. They just feel like being generous and giving a gift. Or they have a very large estate that is going to be taxable under federal estate tax, which is a really big number, and they want to reduce that taxable estate. Or they might want to transfer some tax obligations to a person who's in a lower tax bracket, or provide for a charity and take a charitable deduction. Remember, if you want to give gifts, to purposefully impoverish yourself to make yourself eligible for government assistance programs like Medicaid, there is a look-back period, and it's a 60-month look-back period. So if the purpose is to make yourself poor so that you're eligible for Medicaid, remember that that has to happen at least 60 months, 5 years, before there would be an application for Medicaid. Otherwise, there could be the opportunity for the state to pull those gifts back. So avoid that. So with gift tax, remember that you can give all the gifts you want to during your lifetime to your spouse. It's called the marital deduction, and there's no gift tax consequences at all. Remember also that you can give as many gifts as you want each year in the amount, in this year, it is $15,000 without having any gift tax consequences. Each U.S. taxpayer can give as many $15,000 gifts as they want to as many different people as they want, and they don't have to be related without any federal gift tax implication. So give all the gifts that you want to give to as many different recipients as you want at $15,000 each, and there is no gift tax consequence. So you ask, when is there a gift tax consequence? There is no gift tax due until you exceed the lifetime exemption. And currently, that's at over $11 million. And that amount is adjusted for inflation, so it tends to keep going up. So really, in your lifetime, you don't have to worry about any gift tax unless you get up toward that $12 million number. And that's if it's a married couple, it's per person. So each spouse can give all the gifts that they want to give, and they have that amount in that lifetime exclusion. The only time there is an impact on that $15,000 is, let's say, if you give $50,000 gifts, then $35,000 worth of that gift would be deducted from the lifetime exclusion. So gifting can be a great strategy if you're a very wealthy person and you want to reduce the size of the estate. But otherwise, just give all the gifts that you want to, keep track of those gifts, document the gifts, but likely, unless you're a very wealthy person that's going to exceed that federal gift tax amount, there's not a problem with giving all the gifts you want to give. So then I'll talk very briefly about federal estate tax. When do people have to pay federal estate tax after the time of death? Very quick review of the rules. The federal estate tax is based on the date of death estate value. That's when there is a look at how much is everything that that person owned at the time of death worth. So that unified credit under federal law is the amount of property that can be transferred at death without any federal estate tax obligation. You first of all can give unlimited transfers to a surviving spouse and to charities. There's no impact there. And as of 2020, the amount that a person at the time of death can transfer is $11 million. It's indexed for inflation, so again, it's actually around $11.6 million now. Each person in a couple can die with that much, and there won't be any federal estate tax. So right now we're looking at around, $22 million or more per couple if they both died in 2020. But even if you're not worth that much money, remember there are other good reasons to plan and have a good estate plan. You want to make sure that you're communicating with your family, that you're communicating with your professionals, that you're leaving the legacy that you want to leave during your lifetime and after your death. Number 7 mistake. Failure to maintain liquidity. Remember that death is not cheap. So people during their lifetime, farmers, other people, accumulate a lot of assets, land, equipment, farm buildings, livestock. But is there enough cash around? At the time of death, we may be dealing with the costs of illness, medical care, funeral expenses, things like that. They all add up. Cash might also be needed at the time of death to continue the farm operations prior to final estate settlement. So I advise everybody, maintain sufficient assets that have enough liquidity so they can be converted to cash and cover those costs. And life insurance might be a consideration. Remember also in the farm situation that if there are certain heirs that are going to either have the option or the desire to attempt to buy out other heirs' interests who perhaps are not interested in farming or the farm assets at the time of death, that provisions need to be made for those with sufficient cash or credit availability to achieve those purposes. Life insurance, as I said, can be a good tool in the toolbox. Think carefully about whether life insurance is a tool that might be useful at the time of death of different people in the farm operation so that that farm operation can continue operating until estate settlement or if cash is needed, as indicated before, to perhaps purchase or otherwise compensate certain heirs in the farm transfer process. Mistake number 8, failure to be organized. It's so frustrating for people when somebody dies that they can't find the records that are needed. So make sure that you're not that person. Put together in a good, orderly way the records that can be found and used by you during your lifetime, of course, but by others at your incapacity or death. A safe place is good, but it needs to be accessible to others. So sometimes that safe deposit box isn't the best place. You can keep some things there, but that perhaps is not the most accessible. So an in-home fireproof filing system can be good. It is an option, but inform others. Again, communication. Have show and tell sessions. Show other people where things are and how you have things organized. Paper copies are really the most accessible. And that doesn't mean that you don't want to have backup copies, things that are scanned and perhaps stored in the cloud or on a CD or on a USB drive or something like that. But having those paper copies are really the most accessible and easy to find. Having those well-organized records, it just helps people so much. Procedures are less time-consuming, less expensive, less frustrating for everybody. So be an organized person. I really am a fan of 3-ring binders. It's a great way to organize things. You're going to have different binders for different things. You can store them in places and have multiple copies. Give copies to the people who need them. And it's just a great tool. It's easy to find. And so that if in your lifetime you're saying, gee, do I need to update my powers of attorney? If you have a 3-ring binder that has all those powers of attorney and healthcare records in them, you can pull that out and say, maybe I need to do some updating. If your insurance records or your will or trust documents are in separate legal binders, it makes it easy for you and others to pull them out, review them, communicate about them. They can really be great tools, so give that some consideration. I mentioned earlier the estate planning questionnaire. That's on Ag Decision Maker. It can be printed or it can be used as a PDF fillable form, and it's a nice tool to help you start putting your information together, getting things in order. It's free to use. You can download it, save it. It's a very nice, convenient tool, and I recommend that to you on Ag Decision Maker. Mistake number 9, failure to build a team of professionals to support your process, your planning process, your communication process. Sometimes people think, well, I've heard that I can buy a kit and do this myself. I can find things online and do it myself. Please, there's a lot of good information for you to read, but build that team of professionals. So who should be on your team? There's a whole kind of group of legal professionals, tax and accounting professionals, financial, banking, insurance, real estate, spiritual professionals that should be on your team. So look at that list right now and say, right now, as I sit here today, is there an attorney who knows me, knows my family, knows where my documents are, that I meet with on a regular basis and can advise me? How about your tax and accounting and banking professionals, financial planning, insurance, and so on? Do you have any gaps in that list? And if you do, think about filling those gaps. And again, one of the most common questions I get, especially as an attorney, is people say, how can I find an attorney? So there's an article for you on Ag Decision Maker. You can look that up and find that, read that over. It has good ideas on there about how to interview people, not just attorneys, but other professionals that you might want to work with. And you'll find in there, you can get it as a PDF, and you can also look at a video that actually is housed on YouTube. We have a YouTube channel that is the Iowa State University Extension and Outreach Agriculture and Natural Resources channel. There is a list of farm management videos, and one of them is me talking for 5 minutes about how to find an attorney. So you can go and take a look at that and get some ideas. If you're looking for an attorney or another professional, it'll give you some ideas about how to do that, and I encourage you to do that. Number 10 mistake is failure to continue the conversation and maintain your plans. Remember that estate planning, succession planning, transition planning, it's never done. It's something that needs to go on over a period of time. So have regular annual reviews with your legal and tax and financial and insurance representatives so that they know what's going on in your life and your ideas might be changing. Reviewing beneficiary designations on your retirement accounts or CDs, bank accounts, life insurance, saying, does my will or my powers of attorney, do they need to be updated? How about life event triggers? Every year there are things that happen in our families, birth, adoptions, changes that might affect our capacity, death, marriages, divorces, separations, moving, changes in our income, our wealth, our health. Those are triggers that may then make a difference in what you're saying in a power of attorney, a beneficiary designation, a will, or a trust document. Take a look at those things. Each year, if you have one of those appointments with these different professionals, it'll make you think about those things and keep your things up to date. Don't expect those people to call you and come in for a review. Take some initiative and do that. As we talked about earlier, stop procrastinating. Schedule those annual checkups to review your plans and circumstances. Have you made your final disposition plans? That's part of the estate planning is never done. Talk to your family, spiritual advisors, local funeral planning advisors. They have checklists, things to think about. Have you made those plans? Many people nowadays make plans for their actual disposition. They may buy a casket. You can buy caskets from local funeral homes, but there are other options too. Cremation actually is a very growing choice among people, but if you don't talk about it and let your family know or put it in writing, then those things can't happen and families may feel uncomfortable about it. So have those conversations. It's all right to talk about these things and not wait until somebody is sick or incapacitated. Here in Iowa, there are monks over by Dubuque who make caskets and urns and things like that. And there are many people that take use of that. This is actually an individual that I know that had the Amish build a bookcase for him with a lid. And he uses that as a bookcase now. And his children know that when he passes away, his casket is already right there. So again, don't be uncomfortable talking about those things. It's better to talk about these things when we are well and healthy and can have positive conversations. It's all part of living and part of dying. And many people are not even aware that you can buy caskets, urns, and so on Walmart.com. So it's more common than you think. So what are your next steps? I urge people to set goals, have conversations, seek resources, communicate with one another, get organized. And again, go in and talk to whoever your professionals are or your ISU Extension professionals. They can help you. People like me, farm management specialists throughout the state. We have many programs and resources, some live, some remote, that have to do with talking about these kinds of situations, talking about your farm transition and farm estate plans. Schedule meetings with your professional team members, people who are knowledgeable in estate transition planning and agricultural law. Prepare for your visit and put together a roadmap of how you can proceed. If we were all together today, I would be asking for a show of hands. So as we are winding this up today, I would say, think about it. Are you going to take action? I hope that you're a person who can raise your hand if today you heard some ideas or some information or something that's going to cause you to take some action and do some things to improve what your plans are for your farm, your family, your estate plan, both during your lifetime and beyond. So contact me. You have my contact information. If you have any questions about farm transition or estate planning, feel free to be in touch and we can schedule a time to talk together about some of these questions. Thanks very much for your attention today, and I wish you the best in the future.